Welcome to another Wealth Lens podcast brought to you from Headway Wealth. Today we have the pleasure of the company of Louise Potts, and she does wills and probate. So Louise, would you like to introduce yourself to the audience?
Yeah, I would. Thank you, Hamzah. So my name is Louise Potts. I've got my own business called Louise Potts Wills and Probate. I am part of a larger organisation called APS Legal and Associates, who are one of the largest and most reputable will writing and estate planning services in the UK. APS Legal actually have over 500 associates across the country who all trade as their own business and go to clients' homes to take will, estate planning and lasting power of attorney instructions. So although it's myself working alone, I actually have the support of a big back office team of people at APS Legal. So that's a little bit about my business. Personally, my background is law degree, postgraduate diploma in legal practice, worked in several different law firms for different years, and then most recently have had some directorship roles at different kinds of businesses, but then came back to my legal roots. I'm based in Newcastle upon Tyne, but I've got clients all over the country, as if there was one good thing to come out of lockdown, it's that everybody is very happy to use Zoom and Teams. So I've got clients all across the country. So although I'm up here in the Northeast, it is a national service that I can provide.
Fantastic. So give us a little overview, if you can, please, on estate planning and why it is so important, please.
Yeah, absolutely. So estate planning is basically an umbrella term for planning for later life. So that would include writing wills, doing some protection of your assets. It could include doing lasting powers of attorney, which some people might be familiar with. It's really an umbrella term for a lot of different documents that would serve you well for later life and would make life easier for your loved ones if you were to lose capacity or if you were to pass away.
So what actually happens if someone dies without a will?
Okay, so if somebody dies without a will, they're classed as dying intestate, which means that their assets are going to be distributed in accordance with something called the intestacy rules. And they are basically rules that have been pre-written by the government many, many, many decades ago. So one of the big red flags that a lot of people don't realise is if you are a couple and you're not married or you haven't had a civil partnership, if one of you passes away, your surviving partner is not automatically going to inherit everything that you own. If you have children, yes, it would go to them. But if you don't have children, it actually, surprisingly, all of your assets would go to any parents that were alive. And if you didn't have any parents, it would go to any siblings that you had alive. If you are married and you die without a will, the likelihood is that any jointly owned assets, such as joint bank accounts or joint properties, they will go to the surviving owner of those. But dying without a will does make it a lot more complicated. You're going to have to apply for a grant of probate without a will, which is far more difficult than applying for the grant of probate with a will. For the sake of not a lot of money, it just makes the process after death a lot easier.
And applying for those grants of probate and other such things, I'm assuming they are quite time consuming because nothing happens quickly.
Yeah, absolutely. So probate is the legal process of managing someone's financial affairs when they've passed away. So that includes their assets, money, possessions. It involves making sure that the wealth has been reported to HMRC to see if any inheritance tax is payable, and nothing can be sold or distributed until the grant of probate is obtained. As I said, it's more complicated if there isn't a will. If there is a will and executors have been appointed, it is the executor's duty to then obtain the grant of probate. That usually takes about 16 weeks, but the actual distribution of an estate can take up to a year. It depends if there's property and assets to sell. So yeah, probate is a complicated process, which is far better done by a professional, and that's another service that I also provide.
Okay. And also, I mean, I have a lot of people that come to me that have, when I ask them, do you have a will? It's something that we ask every single client, and they'll say yes. If it was set up, some of them might have set it up 20, 30 years ago. How important is it for them to review and update their will and estate plans?
I would say that you need to be reviewing your will every 5 years. So, if there's been a marriage actually revokes a will. So, if you've written your will before you got married, that will is null and void. If you're getting divorced or separated, they're big triggers for rewriting a will. If any children come along, any grandchildren, if you move house, if you acquire a lot of wealth, maybe through inheritance from parents. If there's been a death of any of your beneficiaries or an executor, if you buy more property, I would suggest that that is another trigger for rewriting your will, or at least having it checked over. I can update any wills that I have written, but if a client came to me and they already had a will and they just wanted a little amendment because a grandchild had come along, I wouldn't be able to help with that. But once I do a will for a client, I can keep in touch with them over the years to do updates at quite a small charge.
Okay, fantastic. Here's one for you. Can I leave money to a charity in my will, and how does it affect my inheritance taxes?
Yeah, absolutely. So you'll probably see a lot of TV adverts about free wills. They are often advertised by big charities. The reason why it's free will is because there's an expectation that you will leave something to the charity in return for providing that free will writing service. So it's not actually free. But yes, you absolutely can leave a specific gift to a charity in any will that I write. The amount that you leave to charity is then deducted from the value of your estate before inheritance tax is calculated. So it is a good tax planning trick as well. If you want to leave some money to charity to try and reduce that liability, that's something that I go over with clients during my initial appointments with them.
Okay. Let's focus on wills then. Why is it important that somebody has a will? Because a lot of people assume their assets will simply pass to their spouse. Obviously, you did touch on that briefly.
Mm-hmm. So it's important to make a will because if you die without them, as I've mentioned before, the intestacy rules are going to dictate who your estate goes to. And that might not be what you wanted. So for example, I've mentioned before, unmarried partners receive nothing. There might be specific gifts that you want to leave to people. It doesn't even necessarily need to be gifts of value. It might be sentimental items that you wanted to go to particular people. You might have wanted to leave gifts to charities. You might have not had the opportunity to say what your funeral wishes were. Also, without a will, you're not doing anything to protect your assets from the risks of children disinheriting, which I'm sure we'll come on to later. So if you die without a will and you are married, if your estate is valued at more than £322,000, the inheritance is actually divided between your surviving spouse and any children that you have. So again, don't make the assumption that your surviving spouse is going to inherit everything. And that also can be a red flag because I actually have an awful lot of clients who have grown up children, and for many reasons, some no longer have a relationship with those grown up children, and they might not want the intestacy will flow to go to those children. So by having a will, you're in complete and utter control of what is going to happen with everything that you've worked hard for across your lifetime when you pass away.
Okay. And somebody sets up a will and has it up to date. Can their will be contested, and how would they prevent it from being contested?
Yeah, so a will can be contested. So if somebody believes that the maker of the will didn't have capacity, if they didn't have mental capacity, it can be contested. If anybody believes that there was any undue influence, so any pressure on that individual when they were making the will, if they think that there was any fraud or forgery involved, which obviously you're really going to mitigate that risk if you're using a professional to do your will. One of the things that I obviously do during my appointment is in the background, I'm always assessing for mental capacity, and I'm always assessing for any undue influence as well. So by having a professional writing your will, you're really reducing the likelihood of anyone contesting on that part. Another big thing to be mindful of is if there are people that you are excluding from your will who might have expected to be included. So I just mentioned the scenario where there might be some estrangement from grown-up children. If you haven't got a will with an exclusion statement, which is basically a statement saying, I've got mental capacity, I've excluded this person, and these are the reasons why, that person could very well contest the will, and it would go in front of a judge, and without an exclusion statement written, the judge would have no idea why that person has proactively been excluded, and your estate could end up going to someone that you didn't want it to go to.
Interesting. Moving on to trusts. First of all, I mean, we do a lot of trust planning for clients, obviously within wealth management.
Yes.
Just briefly tell us, what is a trust and how does it work in estate planning?
So the trusts that I do are on-death trusts, whereas the trusts that you guys and your colleagues will do are lifetime trusts. So my trusts come into action when somebody has passed away. So the trusts that are commonly used in wills in England and Wales are to protect assets from particular beneficiaries. It can be to provide for children who are too young to get their inheritance. So if we've got some parents who pass away and their child is under 25, they might not want that child to have inherited a big lump sum of money at that time. So we can set a trust up whereby that money is drip fed to them, trustees manage it, and the child would have to go to the trustees to say, could I have some money for university, a car, my first home, and they would make decisions along the same sort of lines that their parents would have. We can include trusts that protect people who may be vulnerable. So I do have a lot of clients who've got grown-up children who either have difficulties managing money, or they are vulnerable. They might have addiction problems, or they may have been exploited for some reason in the past with regard to money. So in that situation, we can set up special trusts so they don't actually have possession of the money. And a big one that I get a lot of clients asking about is, how can I protect my children's inheritance should my spouse go on to remarry, or should either of us need to go into care? Which is probably going to be your next question about, is there anything that people can do about avoiding care fees or reducing their care fees?
Well, I actually had a conversation with a client. I think I sent you a message while I was with them, that was around care home fees and later life care, essentially. And what people are quite often worried about is that if they needed to go into care, would their spouse be forced into selling the property, and then it affects their what they pass on to the children, etc., etc. So is that something that you can help people with as well?
Yeah, so this is a golden nugget piece of information that so many people are completely unaware of. I can write a will whereby I am going to ring fence 50% of your property, and if you also wanted any other jointly owned assets, such as joint bank accounts, from the risks of disinheritance. So there are two big risks for your children disinheriting. One is that your partner remarries, and the second one is care home fees. So I'll give an example. So most people will own their property as something called joint tenants. So we've got a couple, they own their home, and joint tenants is a way of owning the property in property law. And if one passes away, the surviving partner, surviving spouse, inherits that whole property. Now, at the outset, especially when you're young, you think, yes, that is exactly what I would want to happen. But as we get older, that comes with risks. So one of the risks is the care fees. So let's say we've got a man and a woman. The woman passes away and the man then owns 100% of the property. The man then has to go into care. At that point, the local authority are going to do a financial assessment to work out how much that gentleman needs to pay towards their care fees. And they're going to look at three pots of money in this order. So pot one is, what income does the gentleman have? Does he have any pension income? Does he have any benefit income? That would be taken. The second pot of money is, do they have any savings above £23,250? If the gentleman does, then that amount is expected to be put towards the calculation for the care fees. And then the third pot of money is, does the gentleman own a home? Now, because at that point his wife's passed away, he 100% owns the home. The local authority could A, force a sale of the property to cover the care fees, or B, put a charge on the property so when it is eventually sold after he passes away, they recover all of the fees that they're owed before it goes to any children. What I can do is change the way that a couple own their property. So they own it as something called tenants in common. So the husband owns 50% and the wife owns 50%. We're using husband and wife in this scenario. The wife passes away and she has left, via the will that I've written, her 50% to her children via a will with a property protection trust. Her husband is going to retain a lifetime interest to continue living in the property. The children can't force him to leave, can't force him to sell the property. If he wants to downsize, he can. That's absolutely fine. But the good thing here is if he goes into care, the local authority are going to see that he only owns half the property. So they're going to do their calculation based upon 50% of the value of that home. So for the sake of an extra couple of £100 on top of a basic will, you are ring fencing 50% of the value of your home for your children. Now, that is also very, very cleverly used with regard to protecting against what we call second marriage syndrome. So if someone went on to remarry, marriage revokes a will, and at that point, your children may completely lose out on any inheritance because your surviving spouse is remarried and everything could go to their new husband or wife. And I'd also like to wave a little red flag for anyone that is in a blended family and stepchildren. Having a will with a property protection trust is vital. So I'm a step parent. If my husband passed away, I could rewrite up my will once he's died and completely remove his daughter from any inheritance. Whereas we've got wills with property protection trusts, so he knows at least 50% of everything is always going to go to his daughter, regardless of if I rewrite my will.
Okay, great. Let's go on to lasting power of attorneys. Again, something we hear quite a lot about. What is a power of attorney or lasting power of attorney, and do I need one?
Yeah, so Martin Lewis actually did a program all about lasting powers of attorney a couple of months ago, and one of the questions was, what age should I be when I set one up? And his answer was 18. So yeah, really, once you're an adult, because unfortunately, loss of capacity can happen to any of us at any time. It's not just restricted to things like dementia or Alzheimer's. I could have an accident this afternoon and be unable to make decisions on my behalf. So a lasting power of attorney is a document that allows an individual to appoint third parties to make decisions on their behalf. So I have got a lasting power of attorney, and my attorneys are my husband and my two brothers. My parents have got lasting powers of attorney, and it's myself and my two brothers that have been appointed to make decisions for them if they were unable to.
Okay, and if they have interesting one that I just thought of. So you've got two brothers and yourself that are your parents' lasting power of attorneys. What if they don't agree on the decisions that they make between the three of them? Does it go to a vote?
It doesn't. So the people that you appoint as attorneys, there's an expectation that you're going to appoint people who get on and who are going to act for the common good of the donor, the person that's made the lasting power of attorney. When I write lasting powers of attorney, I always say that the attorneys can act jointly and severally. So that means they can act all together if they want, or they cannot actually also act individually. They don't technically need to go to one another for sign off. It's very uncommon for attorneys to disagree. Hence the fact that there's no board which sort of negotiates or mediates in that situation. I would always say whoever you're going to appoint, you need to trust them, you need to love them, they need to be people that you know would make decisions that you would want, and the people that you need to appoint really need to have the kind of relationship where they're going to get on and support one another.
And so the benefits of setting up a lasting power of attorney?
Yeah, absolutely. So there are two kinds of lasting power of attorney. One is for property and finance, and one is for health and welfare. So the property and finance one allows your attorneys to make decisions with regard to anything that you own, your house. It allows them to contact utility providers, your bank, your mobile phone providers, access your bank accounts, be part of any financial assessments that local authorities are doing regarding care. The health and welfare lasting power of attorney allows your attorneys to be involved in any decisions about medical treatment, care, where you're going to live, who can come to see you. Just to give you a bit of a real life situation, if we've got a client who's perhaps got dementia and they've already had the lasting power of attorney set up, their attorneys would be able to make decisions about what happens with them medically down the line. So I had a client who had dementia. He was in a care home and he actually got diagnosed with cancer. And they knew that their dad would not want to go through the process of having cancer treatment. Now, because they had an LPA, they were able to refuse the treatment, whereas the medical people involved, the medical team, were actually wanting to go ahead with the treatment. Now, without an LPA, the medical team would have just made their decisions. So they're very beneficial, and it makes life so much easier for your loved ones, because if you don't have a lasting power of attorney and somebody loses capacity, your loved ones are going to have to apply to court for something called a deputyship, which is a lot more expensive. It takes a very long time, and on an annual basis, you're going to be audited. Whereas with a lasting power of attorney, everything's in place, ready to go from the moment that we register those documents with the Office of the Public Guardian.
Okay, fantastic. And as you know, quite a lot of our clients live overseas. They repatriate, and when they repatriate, they often get contracts that they go back overseas. If they were working overseas and they needed to set up a power of attorney, is that something they can do?
So anyone who's got assets in England and Wales can have an LPA set up, but it will only cover assets and decisions in England and Wales. The recognition of LPAs varies from one country to another. So some countries might accept an English written LPA, but some might not. And just touching on that, Hamzah, because I know a lot of your clients are expats, just to mention that if a client has assets in a country outside of England and Wales, they really ought to have a will written in that country that is in line with the probate and the intestacy sort of rules of that country.
Yeah, I mean, I remember a lot of the countries that I worked in the Middle East,
Hmm.
the laws were completely different. They were,
Yes.
and you had to get a Sharia compliant will done, and we worked with will specialists over there, and they were quite big on whether you've got a UK will or a UAE will, for example.
Yeah,
There were two completely different laws, and the assets were going to be treated completely different, and also the way that children are treated as well. You know,
absolutely.
if parents died with children, then and didn't have a Sharia compliant will, it was pretty much thrown out, and you followed Sharia law, which not everybody wants.
Yeah,
Um, just
absolutely.
just touching on expats as well. Do you need so obviously you just said there, if you have an expat,
Mhm.
uh, do they need to have a UK will as well then?
Yeah, if they have got assets in the UK, absolutely, yes. Yeah. So one of the questions that I'll run through when I have client appointments is, do you own, where are your assets? Obviously, my wills cover everything in England and Wales. Funnily enough, Scottish law is different to English law, but I am qualified to do Scottish law as well. Um, so I do actually have a client that owns a house in England and a house in Scotland, and I had to write two separate wills for that lady. But yes, one of the questions is, do you own any property overseas? And if they do, that's the point at which I recommend that they have a separate will written, because those assets will not be covered in the will that I write.
Okay, interesting. So just to round up on those bits, if you are an expat and you have assets in uh, the UK and in a foreign country overseas, you should really have a will set up in that country that you're working and residing in, where you have assets there, and also have one set up in the UK. You can
Yeah,
set up a lasting power of attorney for your UK assets, but it might not be applicable for decisions on things that are within your estate but in a foreign country.
Absolutely, yeah. So, if someone had a lasting power of attorney and that they had the health and welfare one, and they became unwell overseas, it is completely at the mercy of that country whether their relatives could use the lasting power of attorney written in England to be able to make decisions about that person's medical care overseas. It would be up to that particular country.
Fantastic. Excellent. Okay. Anything else to add to that?
I would just say that the people that I really feel need to have a will are anyone with children, because you need to appoint guardians for your children. If you pass away, both biological parents pass away whilst your children are under 18, please don't assume that, oh, granny or granddad are going to have them. It is up the local authority decide who has them. So you must appoint guardians for your children. So that is a big client base for me. If you are a blended family, if there are stepchildren, please get in touch. It's essential that you do that, because stepchildren can be so easily just written out of any inheritance after their biological parent dies, and everything is left to the surviving step parent. If you I would say the majority of my clients are over 50 with grown-up children. That is the point at which you really need to be having your will, your property protection trust, protecting as much of your assets as you can, and getting the lasting powers of attorney in place. Because please remember, wills and lasting powers of attorney, they are going to be being used by your family at the most distressing, challenging time. And if you haven't taken the time or the effort to get those in place ahead of that challenging and stressful and upsetting time, you're going to make things so much worse for the people you love the most. So protect your loved ones, protect your assets.
Fantastic. You couldn't have put that better, to be honest, Louise. Thank you very much. So, as we mentioned before, if any of the audience, any of our clients or people that aren't clients that are listening to this, you can reach out to us and we will introduce you to Louise, and I know that she'll actually do home visits in the Northeast, and we can do everything on Teams these days anyway. So,
Yeah,
thank you very much for your time, Louise. Really appreciate it.
very welcome. Thanks for having me.